E&O typically will provide a defense and indemnification for a claim for invasion of privacy. Invasion of privacy claims arise where there's, disclosure of private information that should be maintained private. The laws around the invasion of privacy are different between Canada and US. In the States, it's a lot more established. Essentially, they recognized 4 categories of torts under US privacy laws. First being, it protects against the invasion of private spaces and intrusion into someone's private affairs, protects against public disclosure of potentially embarrassing information. It protects against the disclosure of putting someone in the false light in the public domain. And lastly, it protects against the appropriation of personality for commercial purposes. And in comparison, in Canada, the statutory protection is a lot more piecemeal. There's only 4 provinces that have introduced legislation that protects against the invasion of private affairs and private spaces. And in terms of the common law, they recently recognized that privacy includes the protection of invasion into someone's private space and affairs. But they don't have the same extent of protection. So there's no sort of similar tort that's recognized, for example, for disclosing private information that can be embarrassing to a person. But as we said previously, it's important to understand these nuances, but in general, just being compliant with both the laws of both jurisdictions. And in terms of appropriation of personality, for example, in Canada, it's been recognized in a very limited sense in that, you can't expropriate for marketing endorsement purposes. But, if I'm using personality material, using one's likeness, image, name for the purposes of a biography, then the court may likely find that that's not an appropriation for commercial advantage. So there's some nuances.